Washington Confidential, the Karen Read murder trial, starts right now.
Good evening, I'm JC Monahan. Glenn Jones has the night off. The jury in the Karen Read murder trial had the day off as we neared the end of the fourth week of testimony. Now, you may remember the prosecution called its first witness on Monday, April 29th. So this is our fourth full week with 16 days of testimony so far. And in those 16 days, we have seen at least 40 people take the stand, from family of John O'Keefe to first responders to the Albert family and those who were at 34 Fairview Road the night in question. One of those names that has been floated around but we haven't heard from yet is Brian Higgins. If you've been following the trial, again, you've heard that name before, but his connection to John O'Keefe's death is still unclear. We'll have much more on him later in our show, but we want to begin with today's developments. Aidan Kearney, the controversial blogger known as Turtleboy, was in court today for his alleged interference in the Read case, and our Kirsten Glavin has more on today's hearing.
Well, another setback for Aidan Kearney and his attorneys trying to get this case litigated. Kearney again claims that it's intentional. Aidan Kearney, the controversial blogger known as Turtleboy, back in court Thursday for his hearing relating to the Karen Read murder trial. Kearney was indicted back in December, pleading not guilty on charges of intimidating and harassing witnesses.
I've been able to cover the trial as best I can, but it's difficult to walk around with the sword of Damocles over your head. Constantly feels like you're walking on thin ice when you're out on bail.
Kearney has publicly accused the Commonwealth of intentionally slowing his case down to prevent him from covering the trial. It's a case he has extensively written about.
The Commonwealth itself has been slow walking this case to keep Mr. Kearney away from the Karen Read murder case that he's been seeking to investigate, and there's been all sorts of hurdles on that, and that's just been continuing.
The state acknowledging that they have failed to hand over all discovery by their May 8th deadline.
I regret that I can't report that discovery is complete, but I'm working on it and I've done my best.
A new attorney showing up in place of Special Prosecutor Kenneth Mello, who was not in court again due to health issues. Kearney's attorney firing back, seeking to have Mello willingly withdraw from the case or have him dismissed for failure to prosecute.
I'm going to ask for it within 14 days, Judge, or I'm going to move for failure to prosecute, dismissal for lack of prosecution, because Mr. Kearney deserves his chance to get out from under this case.
The state asking for more time to get the information over.
I would note that I'm not convinced that all of the things listed are missing are what I would call mandatory discovery, but I will look into them all nonetheless.
Some of that discovery, text message extractions. The judge warning Kearney that the information cannot be published or made public. Outside of court, he said he'd comply.
I'm not going to violate a court order. Up until today, they gave us a full data extraction of her phone.
At the end of the hearing, another deadline and another court date.
I think it's becoming increasingly clear that the Commonwealth has bitten off a lot more than they can chew on this case.
The judge is now giving the state 21 days to hand over all discovery relating to this case. They're due back in court on July 11th. Reporting in Dedham, I'm Kirsten Glavin, NBC 10 Boston.
And joining me now is Catherine Loftus, who is an attorney and, of course, has your TikTok called Note My Objection. Thank you so much, because there's so much to talk about. And thankfully, Catherine is going to be with us. When we talked about, you just heard about Aidan Kearney and what his blogging has meant in this case, and the fact that he even himself has his own trial related to it. He's made it clear in everything that he's written and said he thinks Karen Read is innocent, and witnesses in the case have testified that because of what he said and because of what he's written, they've been harassed. We also heard the defense try to keep that out of the courtroom. Judge Kearney, however, said, you opened the door, this is now allowed. Can you just tell me what door was opened and why are we able to now hear about from witnesses that this life has been hell because of something some blogger has been doing?
So what the pretrial ruling was relative to Aidan Kearney and the Turtleboy blog was that no one could bring it up. There could be no direct questioning from either the defense or the prosecution. There wouldn't be from the defense because it's detrimental to Miss Read. But if any of the questioning opened the door and the witnesses responded in such a way that the natural response to the question would encompass the harassment or things that have allegedly come at the hands of Aidan Kearney and or his followers. So essentially what happened was when Alan Jackson asked Jennifer McCabe, what were you doing at Michael Proctor's house? The reason from her perspective that she was there was because she was essentially speaking with Michael Proctor's wife. Now, there's a whole secondary...
To be clear, just to catch everybody up, so basically, why was she going to an investigator's house to talk? And it wasn't to talk to the investigator. She said, I'm friends with the wife, and we are experiencing something awful.
That's correct. And from my perspective, still inappropriate. Even if Michael Proctor's not there, she shouldn't have been at the house if they wanted to meet someplace else. But I do think that it's the kind of the elephant in the room with a lot of these witnesses is what's been going on outside. And normally those aren't things that we take into consideration as a jury. But I do think, and the judge gave, once the door was open, so when we talk about evidence in the courtroom, it's literally like a door. If you ask a question that leads the door to be open to a certain set of information or facts, then it's out there. Once it's out there, then the Commonwealth, they got back up on redirect, basically asked for a narrative about the harassment. So the juries get to see a little bit more of what the witness's state of mind may be. It's not supposed to influence or it doesn't show any, it's not towards Karen Reed's character, it's not to be taken against her, but it's to tell the jury, maybe think about a little bit of what else is going on as to why these witnesses are testifying the way they are.
A little late in the show, we're going to talk about two people who took the stand and had different demeanors, but one of those is Jennifer McCabe. She was the one who testified, like you mentioned, about the harassment. And when she did, when the prosecution was able to redirect and got back up, she turned and looked right at the jury and said, this is what we've been enduring. I can't, just tell me from the defense perspective, the prosecution perspective, what was that moment like?
I thought it was pretty powerful. You know, I think most people watching this case are either on one side or the other. So people really see Jen McCabe as either a villain or they are sympathetic to her. And I think what she was trying to get across when turning to the jury is, hey, I might be up here a little bit defensive. I might be acting in a way, but that's because, I mean, she really pointed her responses to the defense and basically alleging that they were involved with these allegations. And I think that's pretty powerful. I don't know. We don't know who the jury's made up of. I don't know if there's mom. She talked about her kids. And then Alan Jackson got back up on recross, and I don't think he did himself any favors with the tone.
That was one more moment, was when he came back up and there was, I don't want to describe it. You tell us what it was. It came across as a bit of sarcasm or some tone from Alan Jackson that I wondered how it played. Is that being just a strong, good defense attorney, or does now Jennifer McCabe sort of look more compassionate, or people have more compassion for her?
I mean, my initial reaction was, yikes. It felt a little bit mocking. I'm not sure the exact phrase, but it was something along the lines of, you know, oh, you feel bad about the harassment. And I think really, even if people on the jury might not have liked Jennifer McCabe, that certainly went to the Commonwealth's favor, because at the end of the day, we don't like jurors tend to be more sympathetic and align with a witness because they see you're subject to, even if we don't like you or what you're saying, you're up there for a long time. And when it feels like you're kind of being mocked or making fun of the lawyers, making fun of the witness, jurors don't tend to look highly upon. So I was surprised. I was surprised from him that he went that way.
He went there. Okay, we have so much more to talk about. Catherine is sticking around, but still ahead on Canton Confidential, a closer look at testimony from Jennifer McCabe and Kerry Roberts, their memory of the morning with Karen Reed when John O'Keefe was found in the snow. Stay right there. We'll be right back. Welcome back to Canton Confidential, the Karen Reed trial. Jennifer McCabe and Kerry Roberts were with Karen Reed the morning on January 29th. Monica Medea shows us some of their testimony.
Yeah, JC, both women say they knew of each other before January 29th, but they weren't close. And according to their testimony, they were each woken up by phone calls early that morning.
I woken up to my phone ringing.
And did you know what time it was?
4:53.
Karen called me at 5 o'clock in the morning.
It was still dark outside on January 29th when Jen McCabe and Carrie Roberts woke up to frantic phone calls. For Jen, she says it was John's niece on the phone saying he didn't come home last night.
In the background when you're talking.
Karen screaming.
A few minutes later, it's Karen who called Carrie.
I answered the phone, and she said, John's dead. Carrie, Carrie, Carrie. And then she hung up.
At this time, both Jen and Carrie say they woke up. Jen testified to making other phone calls, trying to piece together what could have happened. Carrie says she called several hospitals and police to see if there had been any accidents in the area while she waited for Karen to meet her.
At least 10 minutes. She said, I said, where are you? I'm in the car. And she said, I'm at Jen's house.
That's when Carrie says she drove to meet them.
Miss Reed came running up my walkway. A car pulled up and then a plow.
I was parked right behind them in the driveway.
Jen and Carrie had different memories at this point in the morning. Carrie remembers parking behind Karen's SUV and the defendant pointing out a crack in her taillight, while Jen says Carrie was parked in the street. What they agree on is their next move. The women head to John's home, Jen driving Karen's SUV and Carrie following in her vehicle. Once they arrive, they search the home. Next, they head to 34 Fairview Road.
After that, the three of us got in the car and we drove to Fairview.
Jen and Karen wanted to go back to 34 Fairview.
It's unclear what time they arrived at the Alberts' home, but both women remember Karen being frantic in the back seat and yelling when they drove up to the front yard.
Let me the F out of this car, and she started kicking the door. So I looked over and I didn't see anything, and I looked at Jen and I said, she's crazy.
I saw nothing. She just runs.
And runs with?
Straight to John.
Based on police reports, we know Jen McCabe called 911 at 6:04 that morning. Carrie says she started performing CPR on John. Dashcam video shows one of the first Canton police officers arrived on scene around 6:09. It's at this point Jen and Carrie's memory differs again.
Miss Reed stated that she hit him.
Did I hit him? Did I hit him? Is he dead? Is he dead?
Is that something that she said once or more than once?
More than once.
All right, now at some point, the women say Karen asked them to pray with her. And a short time later, Jen says an officer asked her to go inside to wake up her sister and brother-in-law. Based on their testimony, that was around 6:30 in the morning. Meanwhile, Carrie stayed outside. She called John's parents and says Karen was taken to the hospital in an ambulance. JC, back to you.
All right, Monica, Catherine Loftus back with us right now. Again, that was just part, obviously, of Jennifer McCabe and Carrie Roberts' testimony. These are two key witnesses in the case because nobody is disputing it was just the three of them that morning, however they got together, that showed up and saw John O'Keefe on the lawn. Discrepancy, yes, in some of what they said. Mostly they seem to line up, as Monica was just talking about. Is that enough to solidify what happened that morning?
I think it's interesting. There's always going to be some discrepancies. I was really waiting for Carrie Roberts to testify to see how consistent it was, because really, like you said, there's only three people there that morning. We're likely never going to hear that story from Karen Reed. So when Jen McCabe told the story, to me, Carrie Roberts mirrored much of that. And I think that almost anybody watching Carrie Roberts testify felt that she was credible, she was reliable. I think that's definitely a reason why the defense chose not to cross-examine her.
That was my next question for you, because, again, Jennifer McCabe, let's just point out, she was on the stand starting Friday and then Monday, and she's still on the stand getting cross-examined. 3 days she's on the stand. Carrie Roberts goes up for whatever number of hours, and they don't cross-examine her. Why?
So much of like what we talked about earlier, Jen McCabe really has been one of sort of the targets of defense for quite some time, outside of the three named third-party culprits. But Jen McCabe has sort of been coined as this mastermind of the conspiracy. So I'm not surprised that the cross-examination against her was aggressive. They certainly caught her in a number of inconsistencies. But I think really when you kind of take the extra stuff out of it and you go down to what did it look like that morning? What is Jen's story? What's Carrie's story? And you have to ask, if you find Carrie to be reliable and her story effectively mirrors Jen's, what do we then make of Jen's recitation of her version? So they were very different. They presented very differently. I thought it was very smart of the defense. That's something that's really takes a lot of guts not to do as an attorney, not to cross-examine. But sometimes when you know you're not going to gain anything, and the jury might really not like you going at this witness who has appeared sad, emotional,
yes,
affected quite deeply by this death. It was pretty smart.
A key important fact is Kerry wasn't there the night before, so that could be another reason.
That's right.
Two people they put on the stand, though, the prosecution, were these two sisters. They went on a trip to Aruba with John O'Keefe, Karen, and tens of other people in the weeks prior. What did you glean from their testimony?
So it's interesting. I think a lot of people had some questions about why they were on the stand and what was really the relevance to this.
I'm right there with you.
So I think what I'm trying to really hone in on what the goal of the prosecution is. And they have to, in order to prove her guilty of second degree, they have to prove intent. And they're trying to go to her state of mind. So from my perspective, what they're trying to do by planting these little seeds with different witnesses is that when Karen Read drinks alcohol, there's maybe some triggers around jealousy or anger, and there's reactions. And so I think that they're going to try to explain why they were at the bar seemingly in a good mood. And then there's been a lot of talk during the ride back from the bar to Fairview about Bella's mom and a prior relationship with John. So I think it's not obvious, I think, to the watcher. But what the Commonwealth is trying to do is slowly say, hey, there's all these instances where maybe when we combine a couple of things, there's some explosiveness between the two. Now, we haven't seen actually evidence of that. That's just inferences that they want the jury to draw. But I think that's where they're going with that line of question.
Okay. And once again, keeping Catherine hostage here for a moment, because
happy to say,
after the break, she is going to help answer some of your questions. So don't go anywhere. And welcome back. We have been hearing from you at home as this trial continues. We're trying to bring your questions to our experts. So this one, Catherine, is from Kristen S. She asks, if Karen is found not guilty, what will happen to all the associated parties? Meaning, does anybody have a legal recourse, either Karen, for civil rights, let's say, or McCabe and the Alberts for defamation of character?
I think it's so that everybody asks often, if she's found not guilty, will they go after whoever? No, they won't. So the Commonwealth thinks Karen Read is guilty. We don't want a system where we, charge one person, try them. If they're found not guilty, we try to find the next person. We want the Commonwealth to decide who they think it is. In terms of a civil suit, now I don't practice that kind of law, but I think it's an uphill battle for Karen Read if she's found not guilty. If evidence comes out that she's actually innocent, that there has been clear or convincing evidence that she has in fact been framed by the police or other parties, certainly she can file a civil lawsuit. Whether that's successful is another issue.
Because there's a difference. Right now, it's just reasonable doubt.
Right.
But what you're saying is then the burden of proof would have to be much higher, that this was really orchestrated.
It's actually not much higher in a civil. The civil standard is actually beyond its preponderance of the evidence, which is really more likely than not. It's like a 51% to 49%.
Okay.
So it's actually a lower standard, but you still have to prove the case.
Sure.
And if it's more theoretical, it's an uphill battle.
Kristen, we hope we answered your question, but we will keep talking. So, Catherine Loftus, as always, thank you. And if you have any questions for our experts, we want to hear from you. Email us at canton.confidential@nbcuni.com. When we come back, a look at what's next in the Karen Read murder trial, the defense promising fiery testimony when Brian Higgins takes the stand. But who is Brian Higgins? What we know when Canton Confidential returns.
Higgins. Yeah. What can we expect with that one on your product? Fireworks.
And that is Alan Jackson right there. We've heard his name mentioned in testimony, the name of Brian Higgins. And as you just heard Karen Read's defense team say, fireworks should be expected when he takes the stand. So here's just a little bit about what we know about him so far. He hasn't taken the stand yet, but he is an agent with the Federal Bureau of Alcohol, Tobacco, and Firearms. He has an office in the Canton Police Department. And according to testimony from Brian Albert, Higgins was at the Waterfall Bar on the night in question. Albert also testified that Higgins went to his home for that after party. It's not clear exactly when Higgins left, but Brian Albert called Higgins around 2 a.m. The two reportedly did not speak. What Albert testified to is he called it a butt dial. So how is Higgins connected to Reed? Well, according to court filings from the prosecution, Higgins and Reed previously exchanged flirty text messages. And 2 weeks before John O'Keefe's death, the filing says Higgins went to John O'Keefe's home to watch football, where Reed allegedly kissed him. The defense team's theory of the alleged cover-up in O'Keefe's death hinges on this web of connections that they say exists between the people at the house party that night. The prosecution, on the other hand, we should note, they have not been commenting outside of court. However, they've previously said the defense's statements about Higgins and the cover-up lack evidence. Wednesday, Judge Beverly Cannoni said she was hopeful Higgins' testimony tomorrow can be done in one day.